LTX Plus. We are continuing to break down today's arguments regarding the Murdaugh appeal, and we want to answer all of your questions with our fantastic attorney sitting beside us here, Brian Sheely, giving us his expertise. Okay, we're going to take some of these questions. Are you ready?
I'm ready.
All right, so the first question is coming from T. Brunson over in Manning. For those of us who did not follow this trial closely, what exactly did Becky Hill do that is fueling this appeal?
She directly commented to the jury about how to perceive evidence in the case and most importantly, the testimony of the defendant. So a defendant never has to testify. They're always presumed innocent. And so it's a very kind of a sacred thing when a defendant does choose to exercise the right to testify. And she was saying specific comments like, all right, ladies and gentlemen of the jury, who she's been with for 6 weeks, don't buy what he's saying. Watch his body language, things that implied that he was getting ready to lie. And that is a big no-no. The deliberation room is just for the jurors. It's not for any outside influence other than what is your lunch order, here's where you park, here's when you show up the next day. But to have a court official make comments about the guilt of or innocence, any comment that could influence is improper and is where we are today in this case.
Right. We heard Dick Harpootlian, the attorney for Alex Murdaugh, talking about some of those jurors and how they shared their perspectives about what they remember happening with our clerk of court.
Right. And I think juror Z in the mistrial hearing basically said, yeah, I felt influenced. Mm-hmm. And you know, the legal standard is not that they have to feel influenced. Really and truly, the constitutional legal standard is, was the comment made? And was it something more than just, you know, here's your next break, or here's where the restroom is? I mean, really, that's all they're allowed to say. So if it's anything that is directly consequential to the deliberations that are at hand, I mean, that's a very sacred place, and it's for the jurors to decide amongst themselves after the judge, you know, reads them the law and they've heard the case. So it's not for anybody else, or else it's a big problem.
Okay, let's get to our next question. This is all the way from Char over in Southern California. Here's the question. Due to Assistant DA Creighton Waters' early career experience addressing appellate cases, does he and his team have an advantage in arguing that only a harmless error may have occurred regarding jury tampering, since overwhelming evidence and testimony, especially the kennel video, led to the guilty verdict? Long question here.
You know, I think that is always, well, number one, I mean, his background, he's a great lawyer. Creighton Waters, he's vastly experienced, trial lawyer, appellate lawyer for the Attorney General's office. So he's going to be maybe have an advantage on a lot of criminal defense attorneys. The Murdaugh team are also excellent lawyers. They also do appellate work, a lot of trial work. But you know, I've been thinking a lot about harmless error today. And, you know, the big legal issues were going to be the jury tampering issue right out the gate, and then the bad character evidence, the financial crimes that the court spent a lot of time arguing. But you know, sometimes when a higher court is trying to figure out, you know, was there error by a judge, what happened, you know, the analysis often turns to, well, the guilt was so present, there's so much evidence, like a confession or DNA or other physical evidence, cumulative evidence, that yes, it was an error of law, but it's harmless because of the overwhelming weight of the evidence. And, you know, that's for the judges to decide. I think, you know, Creighton was probably angling a lot for that today. And I felt, especially Judge Few and Judge James were kind of addressing some of the other evidentiary issues in the way they spoke about the fire marking tools evidence. We talked about the cell phone evidence and how there was an improper witness that was allowed to provide expert testimony when he wasn't qualified. These were things that kind of made me believe that they were trying to get over the harmless error analysis, because it wasn't just a foregone conclusion. I mean, this is not, a lot of defendants confess or interrogated and admit their guilt, and so that was never the case here. So when they were moving along to the other pretty major issues, to me that was a harmless error analysis that I think if the court comes down on a major legal issue, they could also say, well, listen, this wasn't harmless. There was lots of things here that indicated the state didn't necessarily have, you know, just an easy conviction.
I want to make sure we get this next question in. This is from Kim H. over in Sumter. Who do you say got the upper hand on the Becky Hill segment of this hearing?
I think the defense did. And I think a lot of it had to do with the way the court conducted its analysis of Miss Hill's conduct. They basically said, aren't we all in agreement that what she did was misconduct? And I think, they came down on Mr. Waters in that regard and kind of forced him to admit, yeah, it really was. Mm-hmm. And so that, to me, I feel getting Creighton, the state, to kind of concede that point, that it was bad and really bad. And then, but, did it influence the jury? And again, the constitutional analysis is not did it influence them. It was it said with the intent to influence. So, I mean, he admitted it was bad and it was said. So I think that with that question, the defense won the day on that issue.
Those keywords are everything.
Everything.
Everything. All right, Brian Shealy is going to be staying with us here on WLTX Plus throughout the rest of this Wednesday night. So get those questions in. Stay with us, though. Much more to come, again, right here on WLTX Plus.